Welcome back to another episode of Divorce at Altitude. This is Ryan Kalamaya. This week I am joined by Amy Gosha, my co-host. Amy, what are we talking about today?
I'm talking about a topic that's really important about how you divide property and then also how can that affect spousal maintenance in Colorado. So we have in divorce cases, we have support issues like child support and also spousal maintenance. But does property get divided first and how does that affect spousal maintenance? Because it does in Colorado.
It does indeed, and we have talked about this previously, but we felt like it was going to be helpful because I've had several cases recently where people that kind of payor, I've represented the payor, and the first thing when they came to me for their divorce is, okay, hey, I'm cool with dividing equally everything that we've accumulated. We've acquired substantial net worth, and let's say that we've got $50 million. And am I going to be paying spousal maintenance? And that is different than maybe we've acquired $5 million. In the marital estate is $5 million. So, Amy, are you aware of any case that says that when you hit 4 million or 6 million, that Melanie Wolf, she's going to get fill in the blank amount, that all of a sudden she is either ineligible or definitely eligible for spousal maintenance?
The statute says that like you have to be at least married 3 years, but that doesn't apply for those high net worth cases. So no, there is no pay.
So there's no law that says that there's just this threshold. And again, we're going to get to the lawyer answer of it depends. And so for people, often if someone comes to me for $100 million divorce, I feel fairly confident that if Melanie Wolf is going to get $50 million, that she's going to be fine with $50 million and can use whatever money or property she is allocated to pay for her reasonable needs. But there's not a bright line rule. The statute does not say that if you get X amount in property that you do not get spousal maintenance, but it is one of the first questions that, like, Eric Wolf, if he is the business owner or he's the one that is likely going to be paying, because the real focus is going to be on his income. And even if he's making significant income, then he's going to be worried about maintenance. And Melanie undoubtedly is going to ask her attorney, hey, Amy, I should get spousal maintenance, right?
Yeah, because if it's Melanie Wolf who, let's say she stayed at home and took care of the kids and allowed Eric to build the business, she's going to say, I have no earning capacity now. Like I sat here and supported Eric and I've been married this amount of time. I should be entitled to spousal maintenance.
Yeah, I see this in particular in long-term marriages where people long-term, generally, they're going to be older. They also might be from different areas. I went to college in University of Virginia, and I played baseball in the North Carolina and Alabama and all over the place. And people from the South generally have a little bit more kind of cultural, they're more comfortable with kind of a traditional model. And so there's this kind of perspective that can come up against the law. But let's first understand property division in Colorado. Amy, because we'll get into first you divide property, and how you divide property then will impact spousal maintenance. So let's start from providing the groundwork. Amy, how many times have you been asked? Colorado is a 50-50 state, right?
Oh, yeah, all the time. And it's my saying, and I'm sure yours is, Colorado is it's equitable, not equal.
The fair is the four-letter F word in a divorce, and someone's definition of what's fair or equitable can really be up for debate. But Colorado is an equitable distribution state. Doesn't mean it's necessarily 50-50, but I think the starting point for many people, including judges, is 50-50. But the factors that go into the equitable distribution is going to be the length of marriage. Actually, the length of marriage is not an explicit factor under 1410-113. In talking with judges, when I do the kind of guidance on financial matters for baby judges over in Vail every year in September, without a doubt, they definitely consider it. I've asked for a show of hands, and everyone, even though 1410-113 does not say length of marriage, it absolutely is something that judges consider. Would you agree with that, Amy?
Yeah, I absolutely would agree with that. And also, I think like when property was acquired, like people might come into the marriage with property, but if you put it all into a marital residence like 20 years ago, like good luck in trying to prove contribution.
Absolutely. So the contribution, including explicitly in the statute, the contributions of a homemaker. And so I think the judges they really are going to focus on, especially if there are kids involved. If Melanie Wolf was the one that took the kids to doctor's appointments and the school activities, the sports and all of that, that then allows Eric to grow the business or go to work and generate income. And so that those contributions are evaluated, certainly, but most judges are going to really take that into consideration. But also, what if someone had, if Eric had family wealth before, or like he inherited during the marriage, those are the things that really are going to be considered. But the value of the assets is really what we're getting at, though, is if the marital estate, which is going to include real estate, brokerage accounts, retirement accounts, businesses, all of those things, the amount that we are talking about will matter significantly when it comes to spousal maintenance. And we'll get into that next, but it bears repeating that how you value property does matter. So if there is a business, if you can have experts disagreeing on the value of that business, and that can really drive conflict and disputes in the divorce. But also included in that is the character or the nature of that asset, that the property. So if we're talking about, for example, a $10 million marital estate and $9 million is in stocks and bonds, that is going to be different than a $10 million estate that is composed of a business that Eric Wolf owns or is going to be the operator of, and that business is worth $9 million. And like he can't just go in and sell or transfer the business to Melanie. So the character of what the marital estate, as well as the value of the marital estate, is going to really be important for whether Melanie's looking at spousal maintenance.
Yeah. Kind of the hardest situations is like the one you were talking about. If the business is the main asset of the estate, looking at, okay, so Melanie might want half of the business, but how is Eric going to pay that out to her plus support? So that's also what we're talking about and how division of property affects the support calculation.
Indeed. So if we take that same scenario that we talked about, I think there's a couple rules of thumb. Generally speaking, the larger the marital estate, the less likely there is going to be a need for spousal maintenance. So again, if we've got $100 million, then Melanie, the reason that she's less likely to get spousal maintenance, irrespective of what Eric earns on it, because maintenance is really about future income sharing and maintaining a similar lifestyle. And so even if Eric is earning 10x what Melanie does from his job or whatever he receives, then it's a matter of, can Melanie, with $50 million, can she go and invest that $50 million and generate passive income that is going to be used to pay for her, reasonable needs in her lifestyle? And that general rule of thumb is, the more property that Melanie receives in the divorce, the less likely she is to receive spousal maintenance after the divorce.
Right.
Then we also get into whether there's cash in liquid assets versus illiquid assets. And that, I agree with you, Amy, is the trickiest situation. So again, if we have an extreme example, if there's $9 million in a business for a $10 million estate, and Eric gets that $9 million business, then what are the kind of potential sticking points for spousal maintenance?
Well, yeah, with sticking points, because you talk when you look at the factors, it's not just the need of the spouse that's receiving it, but the ability of the spouse who's paying it. So if there's a note that I always say no, like Melanie has to get her equity out of the business and it's going to have to come over time if there's no other way to pay it. So it's Eric paying her a certain X amount per month. That really lowers his ability to pay support in addition. So that's why it becomes so tricky.
Yeah, and when you look at if you've got a let's say that we've got a $9 million business, and Eric doesn't have 4.5. We're talking about an equal division of property. Melanie is owed $4.5 million. Then really what we're looking at is a significant amount of there's going to be an interest or there's going to be a promissory note for that $4.5 million, and Eric's going to have to pay her for the note. And so every month he's going to, and let's say we have a 6% interest rate. That is $270,000 in just interest for the year. So you divide that by 12, and even if Eric's earning a significant amount of income, he's got his own reasonable needs. He's got his living, the rent or a mortgage, and he's going to be unable to pay for those as well as what he owes on the property and then maintenance on top of that. But on the flip side, Melanie she's not going to have the money to go and invest the same way. And so we're looking at it's this kind of sliding scale. But one thing I think people kind of misunderstand or think about is that there's this kind of threshold of that if Melanie is going to receive $1 million or $2 million, that all of a sudden she's ineligible. It really is going to depend on is she going to get $2 million in retirement accounts and she's 45 years old? Why might that matter, Amy?
She has the ability to still earn. Whereas if you're looking at if Melanie was 60, that would be very different because
And the other thing too is that if she's going to be given, let's say there's a significant age difference between Eric and Melanie, and Eric has accumulated significant retirement funds, and that's what we're really talking about with the marital estate. She's going to get $2 million in retirement funds. That doesn't really do much good for her at the age of 45 because she has to wait until she hits 59 or 65 because she's going to be taxed on that. And
for
she's not.
yeah.
We also need to look at so we look at the age, we look at what the composition of the property that Eric gets versus Melanie. And what about a house? If Melanie is going to get a significant asset in the house, is that asset income producing?
If she, yeah, exactly. And so that also affects like her income and her needs. So we want to give her income producing asset. If we can.
Yeah. So if she receives the marital house and that marital house has several $1 million in equity, it's non-income producing. So that's going to really matter. But if, she has that equity, then is she likely going to have a significant mortgage? These are the sorts of things that people really need to understand is if you keep the mortgage at 2.5% because you locked in 2020 or 2021, that's going to matter as opposed to like whether she's going to have to refinance. What people get in the property division really drives the spousal maintenance award, but you're also going to really look at the lifestyle. Why does the lifestyle matter when you're talking about Melanie gets $2 million versus $5 million versus $10 million in property?
It also is going to be like the length of the marriage, but also if there's kids involved, especially like you don't want them having these disparate lifestyles with mom or dad, where like dad, they're jet setting in private planes, and with mom, they're taking the RTD bus to things.
Yeah. And I guess one of the points to make here is that two people or two couples living let's say they have $10 million and you're talking about two different marital estates, $10 million, and all things being equal. If Eric and Melanie kind of have this jet set lifestyle, I see this in Aspen where they're flying all over the place. They're going to West Palm Beach. They're going to St. Bart's. They're going to Costa Rica. if you're trying to keep up with the Joneses in Aspen, you are spending a significant amount of money. If you have $10 million and you're in, let's say, Grand Junction or Denver, and you have a very kind of modest lifestyle, if your friends and family, your neighbors, if they would be just shocked that you had $10 million, and it's because you have lived a very unassuming lifestyle, that's going to really impact whether or not you're looking at spousal maintenance. Because if Melanie is in Aspen and she has significant housing expenses, but then she's also accustomed to the same or kind of a rich lifestyle, that's going to be relevant to whether or not she's going to get spousal maintenance, all things being equal, to Melanie down in Denver or in Grand Junction, where her lifestyle is not the same.
And I think the caveat too is that, like I always tell clients, it's more expensive when you have two separate households. So that's also taken into consideration, because like Melanie might come to me and say, I had X amount to spend at the Prada store. And we have to look at also what are the expenses on both sides moving forward.
Yeah, and my observation is that usually what it comes down to is there will be these competing narratives. So Eric will say, "Hey, Melanie's getting 5 million or $10 million." And the law does say that, and I think it's frequently overlooked. There's just kind of this immediate jump to the guidelines, and you get income or you get spousal maintenance. And really people, and I think it's part of it. We recorded this episode on the proposed changes to the rules of civil procedure fairly recently. There's been a fair amount of changes to 1410-114, and we had an episode with Robin Beatty. And what in essence happened is that the tax laws changed with respect to maintenance. We had a Band-Aid that we applied to fix the spousal maintenance statute in Colorado, and it was to account for the taxes and the lack of tax consequences as a result. And so we have it. And then we also had these advisory guidelines on both income and duration. And really what's gotten lost in the shuffle, because the statute's so repetitive. I just recently went through this. It goes, you have to go through income once, twice, three times. But like really what's lost in the shuffle is that there is a threshold requirement. And it says that if the court cannot award, or it can only award maintenance if it finds that the recipient, so Melanie Wolf, if she does not have sufficient property and an inability to to generate income on her own, like through work, to meet her reasonable needs, then she gets spousal maintenance. And so Eric is going to really focus on how much property she gets, his ability to pay, and like he'll criticize Melanie's cost of living and say, things are changing. We cannot maintain the same lifestyle after the divorce because we have two households, we have two houses, we have 2 gallons of milk that we need to put in our respective fridges. And that is the cold reality. There is an element of truth to that, but Eric's going to really lean on that narrative. And Amy, what is Melanie going to really focus on, irrespective of the property? Is she really going to talk about how much property she gets?
No.
She's going to focus on Eric's income and
Totally.
her expenses and how she shouldn't have to change her lifestyle. And so you get, and really it's like the income aspect, because there's often in these, even if there's 10 or $20 million, they accumulated that. And we have dual income households. They are becoming far more popular. And so, yes, you could have, what are the circumstances, Amy, if you've got 2 doctors that have just been stashing money away and they have divided $10 million? Is there maintenance in that situation? And if so, why not?
Because they're already, I guess the simple answer, they're already on equal footing.
Yeah, they accumulated. Melanie is a doctor. She can meet her reasonable needs. And so what we're really talking about is someone that is a business owner or some sort of executive. Eric often, and we see it far more now than we did when we first started doing this work, Amy, is Melanie Wolf is out there crushing it. And like they've accumulated substantial wealth, and there's a huge income disparity. And that absolutely can be considered when you're talking about child support. But really, the kind of issue in spousal maintenance is, are we maintaining the same lifestyle? And Melanie, if she's going to be asking for spousal maintenance, she's going to be hyper focused on the lifestyle and all the vacations and everything that they lived on, and how she will not be able to do that. Whereas Eric, he makes 10x and just really focusing on those particular issues.
Yeah, one thing I thought the asterisk to this episode is that there might be a premarital agreement that talks about how maintenance and like waiver of maintenance, but still if it's unconscionable, there could be maintenance. But those documents, that contract can guide outside of what Ryan and I were talking about, which is under the Colorado revised statute.
Oh, 100%. And I think I guess a couple practical things that come to mind is, in these circumstances, I think it's really important to work with a financial advisor, especially like Melanie. She needs to understand, what is she going to get? What are her expenses? And you can have an expert come in and say, hey, yes, she's going to earn income. And we haven't really even touched on this recent case in Colorado, the DePumpo case that came out in 2022, and it basically says that you can't include income from a brokerage account. And this was for child support when the parties never really relied on that during the marriage. And that, I think, really throws a wrench in what we often see. And we've talked about in other episodes too, Amy, is like having an expert come in and they'll say, listen, Melanie's going to get $5 million. What's her income going to be? Is it going to be, and it's going to, as a reminder, it's going to be based on what property she got. Is there retirement funds? You're probably not going to include that as income if it's retirement. But if it's real estate, and if it's personal real estate versus rental real estate, but often what happens is we get into these arguments about stocks and bonds and other kind of private investments. Could she earn 4% or 8%? Because that's going to materially matter for what her income is. And often that comes down to expert testimony. So bringing in a financial advisor or an expert on that issue, I think, is something that people should consider. What else?
What I really focused on recently in my practice is trying to work with a financial advisor early on in the case to do those financial reports. Because one thing we also didn't really talk about is, and I think we've talked about this on other episodes, but maintenance isn't taxable. But when you're dividing property, you also have to look at the tax consequences of like a basis in a marital residence if that's going to Melanie. So I think working with that person early on is super helpful.
Yeah, indeed. And I think also having a financial advisor or some sort of expert, I've done it on my own, where you can, as the lawyer, if you're representing Eric, is really talking about his net spendable income. And so we had an episode on this with Boris Sobolov, but really, and I referenced it earlier, is that Eric, if he earns $1 million a year, Benjamin Franklin famously said there's certainties in life, and those are death and taxes. So what are the taxes that Eric is going to have to pay? So he's going to have to pay taxes. He's got to have a place to put his $1 million head on at night. So he's got to have rent or some sort of mortgage. What's that? Then there's going to be some other things in it. If he's a doctor, for example, he might have significant student loans. So yes, he might make $1 million, but he is going to be different if he's paying out $100,000 or $200,000 a year in student loan payments. He's going to have less money to pay Melanie each month compared to the same Eric Wolf who doesn't have that same obligation. So really getting into the net spendable income, and that kind of ties in what we talked about at the kind of beginning of the episode, Amy, and that is that if there's a significant promissory note for property that Eric owes Melanie $2 million or $3 million or a significant amount of money, that promissory note is going to reduce his ability, all things being equal, to pay Melanie spousal maintenance. And so Melanie, she should be aware of that and negotiate a longer time period, potentially a balloon payment on the back end, and really try to reduce and be mindful of that. I remember working, he's now retired, but I negotiated an agreement at mediation, and I knew that we were going to have very differing views on spousal maintenance. So I represented the business owner, and we got a significant promissory note, and I compressed it. They wanted a longer term, and I said, no, I want to have a 4 or 5 year time period. And it made my client's ability to pay spousal maintenance, it was impossible. Like, he couldn't do it. And they didn't realize until after the agreement was signed, because we settled at mediation and we're like, okay, we're going to go to trial on spousal maintenance. And then once they saw the calculations of the net spendable income, they realized the impact, and they were like, oh my, like he can't pay it. And that, I think, was just a huge oversight by that retiring attorney. And it's just something that people need to understand. Property really can impact spousal maintenance.
Solutions, like you're saying in those cases, I call it the hybrid approach, where maybe you, like the person who is receiving maintenance receives more of the liquid marital property, and then it reduces the maintenance obligation. So there could be like a prepayment of partial in property to make the maintenance obligation a little less. So
But
sounds like
indeed, and yeah, most judges, we started at the outset talking about equal divisions and whether it was equitable distributions and all of that. One thing that we do see is Eric will either voluntarily agree, or the court will say, I'm going to award 60% or 55% of the marital estate to Melanie, because then it obviates the need for spousal maintenance, and judges are more likely to do a property division of disproportionate allocations as opposed to dealing with spousal maintenance. And why is that, Amy? Why don't judges like spousal maintenance?
I think like I talked to one judge and she said it's right in the statute that I'm supposed to divide property before I award spousal maintenance. So it goes back to that threshold kind of argument. But I think also spousal maintenance, if it's always modifiable, if they order it, then they're constantly going to be seeing these parties back in court.
And so there's certainty, and the judges, their dockets are jammed up, and then it just results in these constant arguments about, okay, Eric's income went down, it's going to go down. Okay, oh, now it's back up. And what do we do about that? Judges, I think, generally are more inclined, I've heard universally from judges, they're more inclined to do a disproportionate allocation or divide property. And so my kind of examples earlier about 50 million or 25 million and all, those are big numbers. If you're talking about an equal division, then that is something that in and of itself, you can understand that, like, the interest or the return on investments for $25 million, it's a significant amount. I think you're looking more at the disproportionate allocations when you're talking about $10 million or below. When you're in that range, I think that really, because the rationale, the judges and everyone's going to say, Eric, listen, you're taking a hit, you're getting less than 50%. But especially if Eric is my age, he's 46, he's got the future to rebuild, and he's going to be able to rebuild a lot faster and over time eclipse Melanie. And so this is a one-shot deal for Melanie. And that is something that judges, when they consider the economic circumstances, they consider the age and all of those different factors, they are going to look at a disproportionate allocation in that circumstance. And then,
Yeah.
Eric's going to say, I'm the one that accumulated this. Like, I earned this. We're talking about significant wealth. And so those two competing interests certainly clash, and judges can disagree about how that all matters. But I think people should understand the strategic considerations in their divorce negotiation and how property really impacts spousal maintenance. Because whenever someone says, am I have to pay spousal maintenance? I always am like, it depends. It depends on what you're going to do in property. I first need to look at the property before I can make any sort of firm opinion on spousal maintenance.
Yeah, because whenever someone comes in, they're like, how much maintenance am I going to have to pay? And how, and it depends. So it's hard for us to wave our magic wand right then to give an answer. And now I think everyone can understand why.
Indeed. Thanks for joining us on Divorce Altitude. If you enjoyed this, please share it with a friend. And we always look for feedback. Shoot us an email. Our info is online, and we always appreciate likes or giving us reviews, positive reviews, 5-star reviews online. Wherever you're listening to your podcasts, appreciate the support. And until next time, this is Ryan and Amy at Divorce Altitude.